Hi, have you ever had a buyer that wanted to assign a contract? One of the issues that I find that many agents are struggling with is the issue of assignment and how they really work. So let's take a look at a contract here in Florida where I am at. The assignability clause states buyer may assign and thereby be released from further liability under the contract, or may assign but not be released from liability on the contract, or may not assign the contract, and if no box is checked, then the buyer may not assign the contract. Nothing in here talks about the seller having to agree or give permission to an assignment. So what does that mean? When you have a contract that permits the buyer to assign the contract to someone else, the seller simply just needs to be put on notice by the buyer that I just assigned the contract to XYZ as the new buyer. Period, end of story. There is no requirement to get the seller's permission. There's no addendum to the contract that the seller has to sign and agree to the assignment. The seller already agreed to the assignment through the assignability clause in the contract. So generally speaking, an assignment is something that investors engage in a lot. Let's say I'm an investor, I purchase a property, put it on a contract, it's going to close in 60 days for $350,000. And I'm going to find someone else that is willing to pay $400,000, and I'm going to assign that contract to the other person, and I'm going to charge them $50,000 as an assignment fee for the assignment of the contract. So at closing, I would be paid that $50,000, and the person that I assigned the contract to is going to close and purchase a property for $350,000. Thereby, I am making that $50,000 difference. And the new buyer, in essence, paid a total of $400,000, the $50,000 to me for the assignment, and the $350,000 to the seller. Now, it's none of the seller's business how much I am getting paid for assigning the contract. That is just between me and the new buyer. And so in reality, how these transactions get executed, and you may want to talk to your broker or your firm's real estate attorney about that, is an assignment agreement whereby the buyer assigns the contract to another buyer in exchange for a certain consideration, in exchange for a certain payment. And that is a private agreement between the old buyer and the new buyer. The seller is not being involved in this. And if any notice is given to the seller, it's simply going to be a notice of assignment that lets the seller know that the contract was now assigned and that now a new person is on the deal as the buyer, but there's nothing for the seller to agree to. The seller can't refuse. And again, it is none of the seller's business how much this other person is paying me as the original buyer for the assignment. I hope this makes sense. And if you have any questions about it, again, talk to your broker. Feel free to contact me if you want to. I can only comment with respect to the situation here in Florida because I'm a broker here in Florida. So in other states, there may be other rules. But take a look at your contract and what the assignability clause states, and then go from there. Sometimes you also may have a contract, an offer made by an investor where the buyer's name is placed and or assigned. So that right there, if it gets accepted, means that the contract can be assigned at any time because the buyer is Joe Buyer and or assigned. Hope you found this helpful. My name is Thomas Hyman with Realty Partners. And again, if you have any questions, feel free to reach out to me directly. Thank you so much.